Question: what are a few things you would want to know about land registration proceedings? No? This is commonly known by layman as land titling proceedings. Patitulo sa yuta ka. So hello, I am Attorney John Edmond Ruz, and you are listening to our show, Hold Your Ground. Together, we spend a few minutes of the present to gather lessons from the past as an investment for our future. So, atong answer no? What are a few things you want to know? No? What are the few things you would want to know about land registration proceedings? In a Supreme Court case, no, the Supreme Court said, in land registration proceedings, the applicant has the burden of overcoming the presumption of state ownership. It must establish through incontrovertible evidence that the land sought to be registered is alienable or disposable based on a positive act of the government. Since cadastral proceedings are governed by the usual rules of practice, procedure, and evidence, a cadastral decree and a certificate of title are issued only after the applicant proves all the requisite jurisdictional facts, that they are entitled to claim the lot, that all parties are heard, and that evidence is considered. As such, the cadastral decree is a judgment which adjudicates ownership after proving these jurisdictional facts. So, taas kito. So, in land registration proceedings, what it really meant was that you, as the applicant for a land title over a certain parcel of land, normally, you have this certain parcel of land, no? Usual scenario. You have a tax declaration certificate stating that you are the owner. However, that is not enough. In order to have this land covered by a certificate of title, you have to prove in the proceeding, in the land registration proceedings or patitulo, that this parcel of land is in fact private property and not part of the public dominion. So later we will discuss the grounds for land registration. When is an applicant qualified and when can a land be issued with a certificate of title? So you must establish, no, that the land is alienable or disposable. So meaning there should be certifications procured and submitted as part of the evidence to state that the classification of this parcel of land that you are claiming is within a classification that is considered alienable and disposable. It should not be within an area considered either as a timberland or a forest land, because if that would be the case, then your certificate of title, even if issued, would not be valid. But there is a good chance also that your application for a land title would be denied if the land title, if the land is within an area classified as timberland or forest land. Okay, so that is the short version of that paragraph, no? That these proceedings are like usual court proceedings. There is procedure, you submit evidence, no? So the effect of this cadastral decree is as if it is a judgment of the court against the whole world, no, except against the state, no? Normally when you file for these proceedings, there is an order of general default. So tanan ng mga tao dapat na inform. All persons who have interest over the land should be informed either actually or constructively. Then after that, once a decision is rendered, it affects all the persons also. So those who have questions over the land, no, claiming ownership over it, must during the proceedings already establish also their adverse claim. So there are a few things here, no? It is undisputed that the landowner was granted a cadastral decree and was subsequently issued an original certificate of title. So this is from a case, no? So the Supreme Court said that in this proceeding, considering that there was already a cadastral proceeding and a certificate of title was issued, it is established, presumed, that the landowner was granted, was able to prove that the parcel of land she was applying for a certificate of title was in fact private property. It is presumed, it can be presumed that the landowner had overcome the presumption that the land sought to be registered forms part of the public domain, meaning from a classification that your land is within the public domain. During the land titling proceedings, you must be able to transfer this land into the classification that it is a private property and you are the rightful applicant over the land. No? So, naabot na ta sa part, we reached the part where the applicant was able to have this parcel of land from a status where it was not covered by a certificate of title. Later, after the proceedings, it was issued a certificate of title. So what if there was fraud, misrepresentation, or a mistake in the issuance of the title? So it would not mean that the government does not have any remedy to recover the property, if indeed it is part of the inalienable lands of the public domain. Meaning, if the property was in fact within a classification that cannot be titled, cannot form part of the private properties, the state always has the remedy, the government, the Republic of the Philippines, through an action for reversion. So before you leave, please do not forget to like our page and click the subscribe button.